puff, pass. True crime chat rats all across the world. We coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that. Puff, puff, pass. True crime chat rats all across the world. We coming through like that. Taking all the facts, put them in a trap. Cause we coming through like that. When you see the scene, I'm a rat in the pack. Rolling with the squad, got the truth in the sack. With the teams, with the schemes, broken dreams in the crack. History's a puzzle and we bringing it back. Taking all the facts, hand deliver to the chat. Whiskers twitching, we be sniffing where the story at. Puff, puff, pass. True crime chat rats all across the world. We coming through like that. Taking all the facts, put them in the trap. Cause we coming through like that. True crime where we be every night. Blues on the table, got the case in our sight. Doing what we do, every wrong make it right. From the shadows we ignite, bring the dark to the light. Crime scene blueprints, mind sharper than a knife. Rats in the basement, but we running the heights. From the alleys to the penthouse, stories collide. Truth in the whiskers, we ain't letting it slide. Got a map to the madness, every clue's a guide. We the chat rats, and we bona fide. Puff, puff, pass. True crime chat rats all across the world. We coming through like that. Taking all the facts, put them in the trap. Cause we coming through like that.
So, bam, what's up, people? This is a real episode of Red House Media. And I am Danny Thomas, whatever that is. What's up, Lawleen? Mary B?
Wow.
Yay!
What a
What
special
up?
stream.
What a special
know.
day!
Look at this shit right here.
Our first
We
super
got our
chat.
first super chat.
Oh my god! That's so cool.
First super chat.
Come on, rats. We can hit that goal in the first 5 minutes. Come on.
Rubicon became a member!
Oh, nice.
I'm gonna lose my mind. That's strange.
Yeah, I'm losing it. Mary B's invisible. And
I'm
losing
invisible
it.
again?
You started to show up, but then you went away.
Why? Alright, I'll come back.
No, just turn your camera off and on like you did the other
Oh,
night.
yeah, that's right. Is that what I did?
Yeah.
Alright.
There you are.
Wait, I'm back?
There you
Oh,
are.
no.
Yep, you're back now.
Hi!
You are back. Bam.
Toy?
Good.
Can you imagine Toy's a member?
Look at this.
Wow.
That's
Super
insane.
chats and memberships. This is awesome.
Oh my god, people are turning green.
Yes. I want to see that damn emoji or your crazy eyed cheese. But yeah, Gingy, I made it $5. $5.
Yeah,
And
this
then
is
it made me
our-
choose too, so I had to choose the other one. So there's a $5 and a $4.99 and $7.99.
Ooh, so what do the members get?
Yeah, what are the perks of choosing the more expensive Mr. Daddy Rat?
I think I'm gonna do some maybe some construction videos for the members, and it's definitely some shorts just for members.
Can you
Maybe.
do construction videos where the guys take their shirts off for members?
Whoop, whoop.
Yeah, they may do it. They are.
I'll sign up right now. Just
They're
kidding.
not very smart men. They will do it. It's hot outside.
Right?
Oh my God! Angel became a damn member.
Angel!
Yay. All right, somebody needs to buy like 10 memberships real quick so we can just all be members. Because I have to get out of the screen to go buy a membership.
I know. I gotta go on a computer and
Come on, buy the panel memberships, somebody.
I know I gotta calm down. I'm so excited right now.
This is crazy.
Gingy, that's just for you. It's a little more expensive.
$6.99 and $10.99. It should not be that. Somebody tell me what it is because it's supposed to be $4.99 and $7.99. Basically, everybody wants the $4.99, but it made me choose, so I had to do it.
Hey, some people like to throw more money around if you're
I mean, what
So
are the odds you get approved
So,
the day
Diane Keaton,
Cosgrove resigns and the day lawsuits are filed on all of the McAlberts? Like, this is just a great day.
I mean, it's crazy day, isn't it? Wow.
who's gonna get the memberships? Ooh,
I
why
don't
is
know.
it taking so long?
YouTube's flipping out right now. It's like, hold on, what's going on?
You're making too much.
Yeah. It ain't about the money. Why didn't they give those memberships away yet so we can see some of these emojis?
Everybody should already have gifted memberships turned on from other channels, but maybe we have to go and do it in yours now that
I've
you're
never
in.
done it in another channel.
I didn't ever think anybody would have to do it here.
I mean, where's Dean when you need him? We need.
Supposed to be here.
Yeah, he's gonna celebrate this momentous day with us.
Yeah, he's should be here.
And
soon.
Janine too. Where's Janine? She's gonna get over here.
Yeah, they'll be here. Glare's going on in 5 minutes.
There is a $4.99 and $7.99, Danny. I can see it on YouTube now.
Okay. Gingy, I don't know where you saw that other one, but they didn't give you the non value. They charging your ass extra, which is legitimately. I mean, YouTube is after my own heart. They're charging you.
And
extra.
my gifted memberships is already on your channel, so that must not be what it is.
Mhm.
Plus,
Yeah, I didn't want the memberships to be $2.
who taxes? Who's taxing the memberships? Is that
Mhm.
federal?
It might be. Like as
I
soon as I
don't.
get to $100, I'll know. They won't let you fill out all the financial stuff until you get to $100.
Ooh.
I can't keep up with like all the stuff when I'm on stream. This sucks. I want to be able to see the actual YouTube what's going on.
I have my phone here on a little stand.
She says she sent 10 memberships, but I haven't seen those yet.
I just saw Diane G's 5, but they haven't gone to anyone yet.
Gingy's gonna send me a pic of hers. That's what she's looking at.
All right.
It shows her
We're
5
gonna work
gifted
out all the
memberships.
memberships.
It shows her 5 gifted memberships at the top, but I don't see Cherries.
No.
All right, let's see. Do
I
I
don't
have
see hers. The gifted memberships didn't work yet. What the heck? Hopefully it didn't charge
Come
you
on.
for
Come on, YouTube.
it.
We want gifts. We're all like waiting for who's gonna get them.
Before all these other losers get in here who usually don't come.
Well, maybe it's waiting until there's enough people to give all the memberships to.
Maybe. I don't know. It's gonna be waiting a long time with everybody that's live.
And Calypso says it won't let her buy or give.
Wow, they take it away already?
Yeah, Cherry's like, just give it some time. We're teething.
It'll work. It'll work. What's up, Dean?
The official first live stream that we can get money for being here, and Dean shows up.
Yeah.
What's up?
Yo.
I said the first time panel gets paid for being here, and you show up.
I'm the
Wait,
one
we're
that
not
I
paid?
told Danny to stream. I was like, yo, are we going live?
Yeah, he forced me to do it
Yeah,
again.
Danny didn't even want to. He was like, nah, fuck everybody, dude. I don't even like my chat. And I said, Danny, you got to give these people something.
That's not very nice, Danny. I
Give it
Young
to-
Dirks are on, Glare's
Yeah.
coming on, and here comes Danny. He's like, I'm going in.
Shove right on up in the middle of them. Give me 20 of them people. Maybe it'll work soon.
Yeah, you just got monetized, so
Yeah.
It looks like it's using the stock emojis for the membership right now too. And I uploaded one, so
Yeah, the crazy IGs. Is that what you did?
I figured the rat would be his first one.
Oh yeah.
This crazy eyed cheese is supposed to be.
Come on, crazy eyed cheese.
It'll catch up, I'm sure. It's overwhelmed right now that this channel made it that far. It's trying to work it out. AI is very confused right now.
Woohoo!
Sweet woman. It's Rat House
It's a-
Media's birthday.
It's a rap party
Right.
tonight.
That's right.
And he
What
has to go till midnight so we can make Mary B's party part of it too.
Oh,
Yeah, if you make this Rat House Media's birthday, I will never forget that. And neither will Fiona, will you? Sorry.
yeah, I can change it later and make a cheaper one. I just didn't figure $5 was.
No, Sean on the Duff got everybody in with 99 cents.
Oh yeah, I bet.
He promoted that thing.
It wouldn't be a bad thing if I had 30,000 subscribers.
So that's how you
Right.
get them quick.
Yeah.
Get some people to the channel.
I'll have to check Gingy, but I usually go on my computer
Yeah,
because I can't look at on the app. It's stupid.
that's so cool.
We know you're very proud, Annie, as you should be. All the rats should be proud. This is amazing.
Yeah. This happened like fast, you know, it took a while, but then it happened fast. Like they only monitored you for like what, 2 days?
Not on the third level. That just started when we were in the middle of the stream last night.
Yeah, right?
It could be
That was
given.
super fast.
I know it was like 6 hours. I thought it was going to take a month. That's what it said. And
They're
step
like,
two,
no, these people
7
are too
days.
good.
But supposedly a human and AI reviewed the content. and
I don't think a human did.
Get after it.
I think it was just the AI.
Oh, dang. Appreciate it.
Steve.
Crazy.
You're welcome.
Now I got to figure out, okay, I got extra buttons and shit. I got to learn how to use them.
Now I own you, Danny. I gave you money and now I fucking
You have
own you. You do my
stock.
fucking bidding, Danny.
Pay to
You have
play.
stock in Rat House Media now, Dan. Dean.
Buddy, buy stock. Buy your stock now while it's low. Telling you, these memberships are going up to $69.99 soon.
And then 420
69.
Right when I think everybody's got it on auto debit.
auto pay.
$69.99, baby. And then the next month I'm gonna change it back. Let me hit a lick, Dean. That's what they call it in the South, hitting a lick.
You want to lick my what?
Exactly.
You want to hit it and lick it?
What kills me is all of the smoking. They didn't say anything about that. So
Oh, they didn't say that you couldn't do that?
burn it down.
I mean, apparently we're like not on a short leash or anything because they approved us right away.
I mean, doesn't Grant have a monetized YouTube channel?
I mean, let's not downplay it.
I'm just saying, like, he smokes the entire stream.
That's true. That's true.
Yeah.
Well, Blair does too. He
But,
doesn't seem
but
to.
Grant's
do it.
smoking supposedly weed, like the weakest weed I've ever seen if he has to smoke all day.
I think he's just like immune.
nuts. I got too many extra buttons. I'm sorry. I do have this hearing to watch. We'll watch it, but not right now.
You know, they put it on the trial channel, right?
Huh?
They put it on the trial channel.
Oh, they finally got it up there?
Yeah, so we don't have
Looking
to look.
forward to waiting on it. So yeah, I'm gonna get that. I don't know. The
I'll,
Boston 25 audio was really good when I was listening to it.
Yeah, it was pretty good.
Dang. But
I like the new guy. He's fun to
Isn't
listen.
there only a pool camera in there though? So shouldn't whoever does the auto be the same anywhere?
yeah, it should be because it's just a pool camera. But it depends on how they route it through their own whatever they use to solve whatever software they're using. We can get a both of one. So Trial Channel is going to edit all the crap out of it.
Mhm.
Dude, this video has went absolutely fucking nuts again. It's crazy. I've answered so many fucking comments today.
I answered a bunch today.
Well, technically, you didn't answer them. You just went on there and called everybody jackass, which is kind of out of the spirit of my responses so far.
Yes.
You know, I
Everyone,
got a notification and it's like Mary B, you jackass. Like, is she talking to me? I had to look it up.
I just went through some of them. I'm gonna go through more later.
It's like the lame comment you said just to go
No.
put on all your videos so you would get comments.
It's just a comment. It helps. I swear it helps.
No, like I respond to what the person said, and then
I
Well,
know
I
what
mean,
he's saying, but I'm saying that's going to be your general lame comment is
that's why I
calling
respond.
people
yeah,
that.
I'm totally using that.
There's like 500 comments, and there's 500 comments under the 500 comments, and I've had to respond 500 times. I'll do it because the video is just roaring. It's like 300,000 or 400,000 views today.
Yeah, it'll be like, how did you get rich? Well,
Yeah.
there's this video of a saw.
Using someone else's music. It was awesome.
And that's in the YouTube short builder. I didn't use anything that they said not to
No
use, man. They did not say to use it, man. So I did.
Hold on, I gotta find one of my comments because I'm funny.
So Dean, you glad to be home?
Yeah, no, I'm super glad.
How's it going at the house? Getting some of Mama's cooking?
Not yet.
What?
Oh, wait.
I
Just
know.
a second.
What?
Danny,
Get
there's
your
a
mom on here.
45-second countdown on your goals. You didn't set it for the whole stream.
What?
It's saying 45 seconds left to meet your goals.
It should be the whole stream.
No.
No, there's a time. You gotta
All right, well then,
do
fuck
the
it.
time.
We lost.
No,
lost that.
we can meet 3 in 45 seconds.
We lost that one.
Well, I think that's a failure for this stream. I think it was good. It was a good stream, guys.
Let's-
Thanks, Danny.
Let's just close her down.
Yep, time to shut it down.
I thought it was going to be cool, but it wasn't. We couldn't even get 5. And why would it set for 17 minutes?
I don't know. Wait. So even if it's after the time, it's not going to go to your goal. You still get the money, though.
All right, let's go back. Let's see if we can just do 5
I think he
again.
did it on purpose.
I see the timer now.
I think he
So-
did it on purpose. He was like, I'll
He
get
had
some
very
people
high
to donate.
expectations.
I'll get some people to donate, and then when they go, oh no, I didn't set the time right, I'll put another one, and people will feel bad.
Come on, guys. It's the first one. Please. We got to meet our goal.
And I was so confident you were going to meet that goal. Didn't know you had screwed with the timer.
No, I screwed it up already. So I started another one. And Dean's going to fill that motherfucker up by itself.
With all that Colorado money.
Hell yeah. Spin that hat money, boy.
Yeah, no.
Hey,
Damn.
Lord
why-
Day.
Your
A
mom
gifted
had gone on a
membership. I
cooking
did-
strike?
I did my part. I
Yes, you did.
became a member, and I gifted.
Yes,
You
very
did
nice.
the work.
Yeah. No,
No,
I don't
they
know.
still are showing that they're up there, but they haven't gone to anyone. I can
They
see
will be.
Dean.
Lolene, we have 3,150 subscribers, so could be going to any one of those people.
Oh, really?
Yep.
You're the
I
only
thought-
person I've ever heard say that they got gifted memberships when they weren't even in the
Oh,
stream.
we do it.
Oh, I get it all the time.
I was in the
Really?
chat.
Really?
And I was
Yeah.
like, oh, my God, I'm finna get one.
Yeah.
And then her ding, and she got one.
Yeah,
She
I've
got it on YouTube.
I've been gifted memberships, and I wasn't watching the stream.
Well, Danny,
Um,
can you not see the list of members anywhere? Just see-
Usually, though, when somebody gifts memberships, though, it does tell you who received them.
It tells you in the chat usually, and it's people in
Yeah.
the chat. But I thought Danny would be able
No,
to see.
it doesn't have to be people in the chat, though.
No.
But can he
Oh.
not see how many members he has somewhere?
Yeah, he could.
Is there maybe a
So there
setting
should,
that you can say like
there
only
should
go to
be
people in the chat?
No, it's
at
a
least
category. I've got a little categories now that I didn't have before. So just give me a
it
second.
should say at least 10 have received gifted, and then like 3 have bought. So you should have something like 13 if they've gone to somebody.
See your members.
Diane's a sucker for goals. You're lucky to have Diane. She's like money rat.
6. There are 6 members. But it, YouTube Studio doesn't update real fast on anything but subscribers. So, but there is 6 so far. But it doesn't show me anything about the gifted memberships.
I think those 6 may have been the purchased ones. I saw
Yeah,
at least
So there
3.
should be more than 6. Let me see. Oh wait,
'Cause
maybe it
there's-
is only 6. We got
there's-
Rubicon, Toy, Angel,
Diane.
Diane, me, and Sweet Woman, and now Clerk.
Clark.
I think
Kirk.
all of those are bought memberships then.
Yeah. Those ones were all. You can check in StreamYard when you go to comments. There's a starred section. Anything that has to do with money instantly goes to the starred section.
Yeah, I can see those.
It's so cool. Give me
So
all
what are
your-
we doing, guys?
We're gonna watch this Karen Reed civil hearing. What are you doing?
I'm gonna watch this Karen Reed civil hearing.
Damn
we have
sure.
a
you
public
are.
lawyer.
Has your mom like stopped cooking because you came home, or what's going on with that?
No, I think she's just been busy.
Yay.
Gingy says, "Congratulations to everybody in the world." Yes,
We're
So how are
going to
you and your brother getting
Disneyland.
along?
we're coming. That's pretty cool, though. I got all new sections. That's pretty cool. Let's see if it shows me anything else.
Dean, how are you and your brother getting along?
Not. I just
Distant.
ignore him.
Oh, your brother. Yeah, tell us about this.
I'd prefer not to.
Oh shit, that's not good.
But at least you got another cat out of the situation.
Yeah.
How is Bro?
What's up?
Yeah.
How is Bro doing?
Bro Kitty. Pretty cute.
Sweet Woman, were you the one who named it Bird Kitty in the Discord?
No.
I think that
I
that
saw the
Gingy?
chat, but I don't remember. Was it Gingy?
it was Gingy or Rubicon. One of the two.
Cute.
So you got to build up $100, and then once you do that, it kicks you to the next step, where I can fill out the tax paperwork.
Ooh, taxes.
They'll take them out before they send me any of my money. Once they're 30%. 30%. But yeah, let's see if we can get this show on the road. See what happens.
There's just so much excitement with all the buttons.
I know it's cool. I didn't think we would make it here, considering it was pretty much a fucking joke when we started.
Right?
I know.
Now it's just a monetized joke. Don't sell yourself short, Danny. This is still a joke. Okay.
Joke's on you.
Now people are throwing money
Jokes
at the
on
joke.
what, 3,000 people now?
Calypso.
Yep, almost 3,200 people. The video is rolling.
And you just have to figure out how to drop us into other people's chats automatically to get that recognition, to get more people over here.
We can do that now. We gotta learn. Gotta learn a bunch of new stuff. Gotta get out there and make that money. Have y'all watched this already today, Lonely? I watched some of it with LYK. The hearing.
I
I
have
watched-
not watched it yet. I was listening to Young
Oh, I-
Jokes, and then I started
did.
Melanie when I saw you went live. So I know basically what happened, but I have not watched it to see how bad the plaintiff's attorney was. I've just heard how whiny and repetitive he was.
Mm-hmm.
Mary B, how much you watch? You get it all?
No, I caught some of it, but then people were interrupting me a lot. So
Dying. How rude.
I know. Why don't they just
We
leave
know
me
Dean
alone?
didn't watch it.
What?
I said we know Dean didn't watch it
See,
No.
I totally watched it
twice.
twice.
So Dean will be doing the commentary here. Sweet one, you've been at work all day probably, huh? You didn't watch it either, huh?
I watched a little bit. Oh, was that
Good.
me?
I watched a little bit with LYK.
I just love the new accent on the new lawyer.
What?
It's hot.
Oh. Yeah, these are just hired guns though. There are no prosecutors and shit up in here. It's like all hired guns.
No, our new lawyer. I mean, Karen's new lawyer.
Oh, the bald headed dude.
A good
That's
guy.
what I'm saying. They're each side has their own like paid attorneys.
Oh,
If you
okay.
didn't see, he did an interview on Larry Foreman about 3 months. It was like right at the end of the trial.
Oh
That
yeah,
was
that's
where
right.
I
I forgot
first
about
learned
that.
about him
I do
on
not know.
DUI guy.
Yep.
Yeah, Genji, I have no idea why yours is showing different prices because I went and checked and it was the $4.99 and $7.99, I think.
Yeah, that's what I saw.
I'll get it. I'll fix it. It's probably like glitching because it never thought this channel was
No,
going to
it's like
get this budget.
memberships are this price for everyone except Genji.
Fiona, Jesus.
Yeah, Gingy's is now. It's now because she's been complaining about it. It's $32.99.
It keeps going up every time she chats.
Yeah, every time she complains, another $6.
Clerk saw the interview. Yeah, it was a very good interview.
Cool. Well, I appreciate y'all hanging out here when the glare is live.
Who?
I didn't
Who's
mean
that?
to do that, but I had to go live today. There's no way I could not go live today.
I know. We have to
I
celebrate.
already didn't tell y'all anything about it until way after I got home and got everything kind of going and working.
I got my notification at 6 something.
Hey, Miss Jessica.
Miss Jess, there are green people in the chat that are not blue. That's awesome. I don't know why it's not using the custom little things I uploaded, but I'll figure that out later. Let's see what this shit's all about. Let's also make sure the volume's up. Oh God, camera guy, chill
Getting motion sickness.
already.
Look at that crowd.
Look
Hey, I
at
recognize some of those people.
God. They're like they're at the heels of West Virginia. Look at that Paulo Glaze right there.
Yeah, he
Freshly-
gets very smiley. Spoiler.
Freshly painted. Mm-hmm. Hear ye, hear ye. Come on.
I guess him and Aaron have made it through Turtle Boy. Their marriage is going to survive.
Diane G, I don't even know how to hold him back yet, but I will
Hey,
once.
that's Evan in the courtroom. Y'all heard that Alan Jackson hired Evan at his firm in California?
Oh yeah. Yeah,
Yep.
the what's his last name?
Woke.
Wolk?
Yeah.
Yeah.
That's
he's
him
there.
sitting.
There he
right
is.
there.
Look at him.
Yeah.
He's so happy. He's like, I love my life.
I think he was valedictorian of his graduating class, like right at when the trial ended.
Did he go to what was it, BU or BC?
Yeah, I think it was Boston something college. Yeah.
Boston College.
Just so we don't forget during the stream, Diane G was the first super chat ever.
Yay.
A simple yup.
Where is Pinky? I bet she
As
would.
if anyone had any doubts, Chat ING would be the first super chatter.
Right.
Seriously.
I swear her chat rat needs to
Oh,
have
yeah.
like a debit card on the desk in front of her ready to go.
Making it rain.
Yep. It's raining memberships. In the fashion of Jen McCabe.
Not getting sound.
That costs extra.
In case it goes back to
You have
1980.
to
I'm sorry.
open.
There's no sound on that part of the video.
Names that we're asking to be dismissed, regardless.
All right, let's skip over to this one. Try it out.
All right.
God save the Queen.
Good afternoon, folks.
Good afternoon, Your Honor. Good afternoon. All before the court is 2483 CV 692. This is the case of Paul O'Keefe and Alia versus C&C Hospitality, LLC, DBA, CF McCarthy. That Alia case is called for status and for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with plaintiff's counsel. And if you could state the party you represent as well. Thank you.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
Good afternoon.
Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Good afternoon.
Good afternoon. Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Charles Waters for defendant Karen Reed. Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. William Keppel on behalf of Karen Reed.
Got it. Okay,
Good
good
afternoon,
afternoon.
Your Honor. Christopher George on behalf of the defendant, Karen Reed.
Good afternoon, Your Honor. Marissa Palladini on behalf of Karen Reed.
Good afternoon.
Keep on coming.
David Acid on behalf of Paul Bar and Grill.
Okay. I'm sorry, did you say the waterfall?
Waterfall, yes, Your Honor.
Got it.
Good afternoon, Attorney General, also on behalf of Waterfall Bar and Grill.
Good afternoon.
Good afternoon, Your Honor. Lincoln Rose on behalf of the defendant, CF McCarthy.
Good afternoon. Okay, that's all the counselors. Good afternoon, folks, and welcome everyone to the event for this afternoon. When I was assigned this case last spring, the first thing I wanted to do was try to get a sense of where we all going to fill in our tracking order and get a sense of what direction this case is going. In the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery.
You got echo?
It was echoing at the beginning, but I think it's getting better.
I doubt it's me with these headphones on.
It sounded like it was getting a little bit clearer. Just let it play a little bit longer.
Yeah, let's see.
And how that's all going. Counsel? And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least to get an idea procedurally where you stand.
Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents from the DA's office, though we are it is significantly deficient at this point. We're still waiting for the records to come in. So we undertook with the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing. That was sort of a self-defining 60-day, whichever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor. So when the stay was lifted, all discovery was served on the parties or thereabouts.
When you say discovery, we're talking about depositions, documents, notices of depositions, or no?
Only one deposition has been noticed, and it's been tabled because we don't have any documents at this stage.
I see. So it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants. That's going in a different direction, but you're pursuing that sort of on your own?
Right, but I anticipate that the defendants have all the same data that was exchanged during the criminal matter, to which we haven't ever received. So we have requested that both from the defendant and we've requested it from the DA's office.
Okay.
It is coming in from the DA's office in parts, and I anticipate we should have it all within the next 21 days, is my guess.
Okay. All right, procedural issues from the defendants. We can start with you, Attorney Seligson.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins.
Mary B found this member emojis. I only uploaded.
I joined up just for that.
Yeah, I'm gonna put a bunch more in there. Bunch of cool
Yeah.
shit.
Fiona should get one.
Yeah, that's all you're getting. So.
That's okay.
Definitely. Well, I don't know if I'll get in trouble for putting the Willy Wonka one in there. I might try.
Who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage in the Sally Port. We asking the court's permission to bring those claims in this case.
I can't use the emojis because I'm not a member. Come on, man.
Because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the House diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the House were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the House was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed, regardless of how the court decides those. We still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond, so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention I'm happy to brief it so that Mr. Diller can have an opportunity.
At a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claims should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
Okay. All right. Let's hear it then from the Waterfall.
Yes, Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff for order extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed to extension? Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to, Your Honor.
Okay.
And then, Your Honor, we're looking at depositions, but we don't want to consider noticing depositions yet until a lot of the document requests have been answered and the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial. But there are a lot of records, as I understand it, that are still to be produced so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right. Thank you. Let's hear from C.F. McCarthy, then.
Your Honor, in a similar vote as to Waterfall, we are putting efficient touches on our discovery responses. The last leg of it is just collecting communications from employees in that incident, some of whom no longer work for C.F. McCarthy's, but we anticipate having that completed in a very short term and getting that over to my brothers.
Okay. All right, thank you. Let's hear from the plaintiffs then, in terms of response to the procedural issue that was raised, in particular by Ms. Reed's counsel. Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your
It's the
Honor.
first notice you've gotten?
Of course, I would
Not
expect.
how the court
that-
system likes this stuff to work, folks.
I would expect the courtesy of a meet and confer, or at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started it in the state court. We're intending to move forward in the state court. We would like to have the state court, Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right. Any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took
But it
place
is, though. It's the plaintiffs. Well, just hear me out for a second. And when you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So this, at its essence, is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case and then brings another motion to dismiss substantively. We're not seeking to.
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. And we'd like to brief that for Your Honor, but we're raising it at the status conference so that, because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right, so I don't know that there's any ruling by the court today that would have to be made relative to that because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case, correct? Yes. There's 5 of the plaintiff and
All right, I made a change on it. So I added a level. So now there's a 299 level.
The fuck?
Just for
Oh, I
Ginger.
want my money back.
Yeah.
No, that's okay. I wanted the mid-range one.
Yeah, I would wait. I would wait a day or two. Let it all kick in. Because, you know, Diane G's going to buy a bunch of them.
there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking order, so you understand what.
I'm going to delete the most expensive one. So hopefully I don't end it unless anybody's already done that one. Which ones y'all get, Mary B?
I got $5.
$5. $5. Nice. All right, I'll check. I may leave them for right now just to let it kind of marinate. But you really should be getting the $5 one.
I was muted. I was saying I do feel a little scammed. I bought the $7.99 one.
Oh, you did?
Shows how
I'm
much
taking
you
it off.
love us, Dean.
Feel a little scammed here.
Dean's the only member of the rat house.
You got
He's a
like the
high roller.
Cadillac. Cadillac.
He's gonna
rat.
get extra special treatment. That's for sure.
So yeah, what comes? What perks come with that, Danny? Is there going to be like some
And he
alone time?
drives to Texas on the weekends. Yeah.
Mhm.
Some one-on-ones.
You get the what's the goggles you can put on? You do the virtual sex thing. That's what you get for that.
Nice. Do I get a Danny sex bot? Is that?
No, it's not. That's not in the works.
Well, then
yet.
give me my fucking money back, dude. This is I was promised certain things.
I need a lot more $7.99 membership to get the robot paid off.
Hey, MJ.
Layaway at Walmart.
Yay. I
Welcome
summoned
to our
MJ.
birthday party. Me and Rat
Yeah.
House Media.
MJ, what's up?
I tried summoning Janine too.
I'm sure they're all in glaring. A bunch of people
I
going
went and
back
looked.
forth.
I was looking for people, but
It's
I didn't
cool.
stay long.
Whatever. I knew they were all on. You know, we can do about it.
Yeah, I mean, I'm not going to say anything, but I will think differently.
I'm not gonna say anything except for right now.
In my mind, without speaking
Just
it on
know
panel.
that if you were in there, I saw you.
But we had to share this glorious day
Glorious.
where YouTube made a bad decision.
The deadlines are now. I have the tracking order. I think basically shows this case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now. right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, the clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now, so I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case. But to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative
Well, you're saying an affirmative. You said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, right?
So it's not an affirmative defense. It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down two separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest may be a more streamlined approach. And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial economy without prejudicing the plaintiff. Discovery is already ongoing. But to have two depositions, for example, of parties in two separate cases, where we can have one and the claims could proceed at the same time, just seems to make judicial sense. That's why we're raising it. But we'd like.
Are y'all still having trouble with the echo?
It is still echoing. Are you hearing an echo, Danny?
Nope.
Well, then it's coming from your
And
headphones.
it's your fault.
How was it come from my headphones?
Your headphones are up really loud and your mic is picking it up.
Shouldn't be.
It seems to do it right when people are transitioning speaking.
I like how Danny was like, it shouldn't be. No, we all agree, Danny.
Yeah.
We all agree it
To brief
shouldn't
it if
be.
the court gives us that permission.
Okay. All right. Now, on that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these two cases and throw it.
All right. Is it better when I'm muted?
Yes. In fact, I think the whole show is better.
I tried to do that before. I lost my mute button. Is that better for you, Misty?
I think that might explain a lot, because I also always hear an echo when Laleen speaks. So that might be the same reason. Thank you,
I don't
Dean.
have headphones though.
No, I mean, because he's hearing you on his
okay.
headphones.
Yeah, my headphones are too loud.
Yeah,
They're
calm
okay.
down, dude. They don't need to be that loud. We're
There's
not watching the
nothing-
Micronauts video.
There's nothing in between my ears, so the sound may be just echoing around in there.
It's like a sound stage in there.
Yeah, until it finds a way out into the microphone. But I'll mute it. See what happens.
As far wide ranging as they just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I'm certainly not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, excuse me, the counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is the cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, that claim is for negligence / reckless / intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is pled in the complaint, that would satisfy the limitations that the case law sets out, the temporal, the spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother, again, they were not witnesses to the event. They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here. If for the sake of argument, there is a remedy here through the wrongful death statute. And the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. We rest on our papers. Thank you, Judge.
All right, thank you. So let's turn to the other defendants if they want to be heard. You've filed separate motions, essentially arguing the same relief, but if you have anything you want to add, you certainly can. Waterfall?
Yes, Your Honor, we have Waterfall. Just very briefly, I think the distinction here the council's making is that these claims, these infliction of emotional distress claims are intended when you're in the zone of danger or you're a recipient witness. And in this instance, it's many, many hours later that the parents are seeing the decedent in the hospital. I think it's after 7:50 a.m. And so based on what the Cohen case states and in terms of the principles that the courts have applied here, it just isn't from a relational standpoint close enough in proximity to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages of the loss of the son, if the plaintiff is making this claim going forward, are in fact addressed in that statute and obviously would be available as remedies to the plaintiff.
What about Semino versus Milford Keg Incorporated? I have a 1982 case that I found talking about the wrongful death, emotional distress injuries. Have you reviewed that case? I'll give this case site, 385 Mass 323. It's a 1982 case. So it would seem to suggest that that emotional distress is really not preempted by the wrongful death statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed and since it wasn't immediately thereafter that they came upon the scene in a roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that, that that's a problem for the plaintiff moving forward, and that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay, thank you. Ferreter versus Daniel O'Connell Sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from C.F. McCarthy's on that. Anything else to add on the motions to dismiss? No. Okay. All right, great. All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely.
Allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iachino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
I do, Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor, does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss. The lowest standard, the Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright line test for such cases. Number three, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout.
It's crazy to look out there and see the super chats.
Well, you've already got your super chat song in mind, so you might as well get toy on creating that clip.
Yeah, we'll figure out something. I'll get all this stuff figured out. I just haven't had enough
Well, you
time.
already said it was going to be the dancing rat and then the Do you even watch the show Lawleen part and all put together in a clip?
Yeah, we'll try. We'll try. Gotta make something. What do you think, Dan? What do you do for your super chats? Just read them.
Yeah, just read them.
That's probably what we'll do.
Yeah.
One day.
But I mean, you can do whatever you want. It's your show.
Yeah, but that's not any fun. Nobody wants to do what I want to do. Damn. That's not how we got here, Dean.
That's fair.
I'm gonna change it. Oh, we made the goal.
Confetti.
Is that what it does? Confetti?
Yeah. Yes.
Virtual clap.
Cool.
Did I miss the first confetti because I was
Runkle.
in the comments?
I didn't see any confetti.
It happens in the comments.
Dang it.
So Runkle will like take a shot of hot sauce
Ooh.
when he hits a goal.
Oh, when he hit
Yeah,
the
you
goal.
got to get creative here, Danny.
I'll set a proper goal and I'll have to a smoking thing. We can puff.
Can we watch
past.
you cut something with a saw in person?
Yeah, I'll just cut this down.
Cut your wiener off.
Oh my god! We're not
Do
gonna
it.
that. We're not doing
Everybody
that.
send in super chats. Danny's going to cut his wiener off.
I think you're the only
I don't
one
wanna
that want that.
Poor
We might
toy.
get a copyright strike for that.
I think you're the only one that wants to see his wiener one way or the other. Like, we're good.
Yeah, can we maybe mummify it afterwards and then give it to me?
He just wants me to mail it to him.
You could do
Wrap
the
it up like a little mummy and mail it to him.
It's true.
neighbors,
True.
the dildo fundraiser. There you go,
Oh
Danny.
god. Oh god. No. We can make that the membership emojis. Little dildos.
I don't
If
think
they're
you
gonna
can
be
do that.
dildos,
I
do
think
them big ones. Come
No?
on.
no, I think you would get in trouble.
What if
Hey.
it's just something that looks like one?
What if it's vague
It's
and only
it's
we
a
know?
neck massager.
Yeah.
Yes, exactly. Plugs into the wall. That's the $2.99 membership emoji. It's the
It's like
dildo.
it's a carrot.
Yeah.
You know?
Exactly. A carrot with eyeballs.
We intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? all to a 14-year-old child woken up from sleep who's already lost two parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness at around 6 a.m. They rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out first the wrongful death statute. It has two components for damages. It has two buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages, the lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings two separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out.
What's up, Janine?
Oh my
There
God.
she is.
I'm I'm half asleep, but Laurleen just called me, so I had to come and say hi. I don't know how long it lasts. I just took
I
my.
didn't mean to wake you, but I didn't think you wanted to miss this.
I know. I love you. No. I'm not saying it like that. But I'm.
Frickin' Laleen.
No, but I'm sleeping.
Steve made me do it.
I'll hang out for a few minutes but I just took my melatonin and I bought this new magnesium with ashwagandha and I'm really excited about it.
Magnesium
and I
is
popped it the
dope.
second that Laurleen called it. I said, "Oh shit!" So I'm sorry I didn't pick you. I just
You
saw
gotta check out all these memberships and super chats that are happening. You did this. You were part of this.
Oh my god, we all did. Jesus Christ, we just got a super chat. Of course, it's Diane G for sake.
First super chat.
Oh my god.
He's already met his second goal of the stream.
Because he didn't know how to set the first one.
Congratulations, brother. Congratulations,
God.
sisters.
Just
Chad,
want-
love you. You all did this. We all did this.
I know, we're that cool.
We
that-
are.
If we can
So
just figure out how the gifted memberships can get distributed, we'll be on point. That's the only thing that hasn't worked yet.
That's right. And
Still
on
learning.
the eve of Mary B's birthday.
Yep.
Oh my
Chat Rat birthday, then Mary B's birthday.
Yep.
Can't stay on until 12
He's
a.m.
way to remember it.
That's okay.
But we're gonna pregame tea tomorrow, right? So
Yeah.
oh, Mary with her DraftKings. Oh, that's hilarious. I don't even understand that, but it's funny. It's some gambling thing, right? So what have
Yeah,
you?
I did good this weekend. I won
I did
two.
awful.
Did you? Oh. How much did you win? I don't know how you win.
I
What'd you
won. I won a total of like $110.
Nice.
No wonder you're trying to sucker us all in.
I know, right? Well, the girls' league, it's usually very small, and I know that there are more girls that are into football, and I know I can find more people. So I did, and now that's a decent prize. So I get $50, 50 something dollars from that, and then I got $55 from my family league, which is always fun to win.
Cool. Oh my God, it's Dean. Hey, Dean.
Yo.
Last time we saw Dean.
Super excited about that, Dean.
That's exciting. I'm excited for you, Mary B. All your winnings. That's like an early birthday present. You manifested that.
Yeah.
Dean,
Well,
tomorrow's Mary's birthday.
Yeah.
I'm sorry, what?
Yeah.
That's why he has to go another hour so we can blend into her birthday. The Chat Rat birthday blends into Mary B's birthday.
Yes.
Whew.
But
Right,
for
that's
those
good.
of us who miss it, we're gonna pre.
I will be missing it.
Right?
We may all miss it.
I'm gonna have to miss it. I'll be listening, but I can't be on panel that long. We have homework to do still.
Aw.
Hey, talking about tonight?
Good.
Yeah, I wasn't expecting you to go live since it was so late, so I was
Oh, yeah. I
procrastinating
just
on
wanted
homework.
to do this and goof off.
I'll still be listening in
Yeah.
chat when I get off.
Check this
It's only
out.
30 minutes left of this video. I'm probably not staying on much longer than that, unless
It's-
Glare goes off and a bunch of people show up. And
So
me
what
and Dean are
happened?
gonna rock this bitch all night.
yeah, we're
Yeah.
gonna pregame TV tomorrow, so we'll do my birthday thing then.
Yeah.
Yes.
You have to make up a
Every
song.
time I plan for it, it ends up being a long ass day at work.
Rap birthday theme song.
Yeah, like a
Come on, boy.
like a Buffalo
She's
Wild
just
Wings
working
thing.
on a Halloween song and all kind of shit.
Well, I mean, for Jesus Christ's sake, do you know how many fucking Libra rats we have? We're gonna be
A
singing
lot.
happy birthday all fucking month, start to finish.
Yeah. People are typically born in a month. though.
We got
Just
Like,
New Year's birthdays.
We
born
got
in a
cusps
month.
on both ends. We got Mary B on one end, and then we have. She may get upset if I say who it is, but I'm gonna out her when it comes for sure. I'll know. Anyway,
Oh, I get a free pizza? Oh, okay.
What? For
See,
what?
I'll get a free Domino's pizza.
pizza.
That's not good for the rest of us.
We gotta
Hey,
find
speak
out
for
where
yourself. I've got a birthday coming up.
And
Oh,
I'll
what are you
Domino's in a
gonna
heartbeat.
get on your free pizza?
That's right, Misty. You know.
What toppings are going on the free pizza?
I usually do bacon.
Nice. That's it.
That's it.
Yes.
So
I don't like
judgmental.
to overload the pizza because then it just gets like very heavy and it doesn't like, you know, you don't want to.
Yeah. Colony pizza gets that way. Yes, it gets floppy. It gets
Yeah.
floppy. But when I do Colony, which is the pub style pizza, this is what I do. Onion, sausage, cherry pepper, hot oil. Sometimes I do mushroom, but it makes it very floppy.
I
But
think
a
they
thin
like it when
crust,
it's floppy, D.
a thin crust.
I prefer when it's hard and stiff.
Don't
Say
make
who?
it perverse.
I prefer stiff and hard.
Pizza
You don't like to roll it up?
No.
Yes, he does like to roll up his microwave Tostinos now,
I do. That is true.
but that makes it
You
stiff when he
just
rolls it up.
fucking lied about rolling it up like immediately right here on video.
Well, so I didn't know that's what I thought we were talking about a penis.
Hey, Laura, Clark, Ingy.
A penis.
Yeah.
That's sausage. She said bacon.
You're right.
We did watch a video on crispy bacon last night. The little kid was born without his
I was
back
in
leg.
the middle of the grocery store while all of those videos were playing, and I was trying
Yeah,
not to make
man,
eye contact with anyone.
Smash Kai got us fucking hard copyright strike.
So why?
Which one?
That was before I came
Kai,
on.
the Hatchet Weldon hitchhiker.
Oh.
Hi. What did Kai say?
Like 3 minutes of a fucking video got us a full copyright strike.
But what was it?
That's it. I'm telling you. That's what
But why
it is.
is the reason? Because it
Yeah,
was
what's the reason?
because it was the
somebody
national
owns that
news
video.
story.
No, because somebody owns that video.
But we were playing Jesus Christ, the house is on fire. The one
They
that Mary
obviously have or
Because like all
because
those
they
clips
emailed
played,
in.
I've heard before, so I
Requested-
figured they were all
requested
copywritten.
it.
So they struck you last night and then they approved your channel.
No, YouTube
those
didn't strike me.
motherfuckers.
The company that owns the video emailed and had the video removed.
Sorry.
Oh.
Mhm. So somehow they
That's
found
so
out we
dumb.
used 3 minutes of it, which I guess they probably got a bot hanging on to it or something. AI.
Why do they care?
How did they do that, Dean? How do they know who-
Yeah, they have bots for that. Like
It wasn't YouTube though. It was this company.
No, I know, right? So like,
Oh, they just attach them like a.
yeah, YouTube has the bots, right? And like, if they recognize, like, their bots will recognize copyrighted material for like other people, right? So like, even you, right? Like, if you put out a video and somebody just watches your video, puts it up on their channel, YouTube will alert you.
So is are his shorts copywritten by him? Like if someone shows his popular one, he'll get notified?
He should, yeah.
You
Unless
better
they make it
copyright strike
transformative.
everyone.
Unless they make it transformative, then no.
Yeah. Kai smashed our stream with a hatchet. It's like he smashed that dude.
Yeah.
Got us. They wouldn't even like, can you edit it out? You know, I figured they would give you like a certain period of time where you could edit out whatever it is and then repost the video.
I thought they did allow that.
Oh, so that's what happens. Every time we play someone else's video, it lets them know.
Mhm.
And that's why they're like popping in here and like, oh, hey, you're watching my. Oh, I thought it was just a
Oh, it's not
coincidence.
just because they love us.
Well, they have to like proactively look for it, right? It's not like YouTube sends them a notification, but if they check in their YouTube studio, they can see. So they have to actively look for it, but YouTube does, in a sense, let you know. Yeah.
All right. Well,
I
that's
kind of
good.
knew that, but I didn't figure it would happen on like news reel.
Well, when you think about it, when the channel got lost last time, that was news that you were playing, and then the copyright was news. So it seems like they have more settings set for them not to be shared.
Yeah. They need to start putting like little
warning to creators that it's
tag is
copywritten
what they click on,
material?
and it just lets you know whether or not that creator allows their stuff to be used on YouTube. But if you're
Yeah, that would
changing
be
it
cool.
enough, then you have fair use if you're altering it enough.
Mm-hmm.
So I
But I mean,
probably
honestly, everything you played last night was a news article. I mean, I've seen almost every one of them that you played before. So I guess it just depends on how much coverage it's gotten, how big it is, and how much people care.
MJ is arguing with everybody again. Look,
she's capitalized. She's warring with Steve about pizza.
No, I think she's agreeing very enthusiastically.
Oh yeah, that's total enthusiasm.
she's
Yeah.
just being mean like always.
Either way, MJ, it's cool. We love you. Fuck yeah, it was.
Now we're talking
I love
cases.
pizza
That's how you eat
enthusiasm,
pizza right there.
ricotta on anything is great. Does anybody have know a place where I could get fried calzones? Calzone.
But I like everything on my pizza,
I think calzone.
especially the vegetables.
That would be plural already. I don't know. I'm sleepy.
I think we just call them calzones.
Yeah.
That's the way I've heard it, but I'm not from Queens, so I wasn't going to argue.
Yeah, that's like a being in an Italian family thing, not a Queens thing. I say calzones when I go to the to the counter to order them, but I say calzone because that's how my father says it. Anyway, but yeah, but I need a place that Steve knows the best. Okay, don't fight with me. She wasn't. That was me spreading a bad rumor. I'm sorry. That was misinformation.
Well, let's see if we can finish this damn hearing.
Yeah, we can
All right,
do it.
I'm gonna go. Bye, guys.
Good
Congratulations.
night, sweet woman.
Good night.
Oh, night, sweet woman. Love
Good
you.
night.
Thanks for the super chats.
Yes,
Of course.
thank you. I'll get it all worked out,
Yay.
bro. It'll be way more expensive and smoother.
Goodbye.
I'm gonna keep changing it. There used to be a place here where you go and eat, and it's like a Tex-Mex place, and you could get these little, cheese tortilla things, and they were like $2, and millions of people started getting them. Not millions, maybe thousands, and it became an issue. So they put them on the menu at $99.99, and people thought it was a joke, and they were like, "No, it's $99.99," because they got tired
For
of making.
bread and cheese.
Wicked
Yeah.
smart.
Exactly. Angel already wants a refund.
It'll get better, I think.
It's going to take time for him to figure out that option.
Yeah, well,
Yeah,
I don't
exactly.
think it's me right now. I filled out my stuff. I think they're just having trouble because they didn't think anybody was actually going to buy any of them.
Well,
They
they
didn't
better get
devote,
their shit together.
they didn't devote any megabytes over to us to help control the Fiesta.
They underestimated the chat rats. How dare they?
Yeah,
Won't
How
be
dare
it
they?
wouldn't be the first time.
How dare you? How dare you? Remember that? Remember we used to play that.
That's what I think of every time I say that. How
I know.
dare
Can't
you?
play it against them.
How dare you? How dare you?
When they boot this damn civil case out, we'll play it.
Nice.
It's full freeze frame though.
Directly contradicts everything that my brothers just argued here in this court, and I see no reason why this court should overturn the good standing law that exists under the Semino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. But the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident. Because as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim to suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own two eyes, I refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions to suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So on that second, we also suggest that you should deny it because they experience the injuries closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenck, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendants Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Kaylee was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down. It's in the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy, to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seeing before? To the extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this. She has always known their vulnerability. And yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired and they are now fair game. Discovery will track how much leaked information defendant should have known would result in distress to the O'Keefe family. To the extent that the defendant suggests that this case sits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases I cite. The Polay case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly, because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc. There are more. This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you. Any response from the defense?
Your Honor, briefly. Firstly, those allegations contained in the complaint are allegations which we will refute. Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of the child who died in the car accident was himself hit. Part of the car accident, gets up, runs to see his son. It's contemporaneous, it's at the time of the event, and the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress claims. So I point that out for the Your Honor. He also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I'd said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue? Anything else? All right, thank you. Certainly, there's a lot to the complaint. And again, for the record, so that people understand this, this is a pre-discovery form of relief that the defendants have sought by way of dismissing certain of the counts that are in this complaint. And the court has to consider the allegations as being truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that might be asked for at some point, that this case will have a very long and tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does. And so as a result, there's appellate processes. And so what I envision for the parties, unfortunately in this case, is a very long and sort of complex process that litigation provides. And you know, this is a civil case. It's not a criminal case. There are 8 parties as I identified, and those are the people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case, I could do this trial this spring if you'd like to. My sense is that there's nobody that's going to be ready to go to trial by the springtime. If you want me to assign a trial date, we could do so. I mean, literally, I've talked to the clerk, we could do it in March or April if you'd like to. But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You have a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. You know, I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties, and there's relatively novel theories as I'm hearing it. But nonetheless, we'll let the parties file the motions that they need to, and we'll address them as each comes. But my point in raising this all is that the parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say that being a judge for many years, you learn things. What you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it. And ultimately, a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers, your clients can ask your lawyers about post-disposition or post-verdict process. It can be really long and arduous. I've had the pleasure of having trials that are 16, 18, 20 years old, and they're still going. Your clients don't have to do that. The clients can try to put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case realistically. Again, we could do it in 2026 in the spring if you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench has been thrown into the works because of this other process. We'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have a mediation process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals, because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but I think it's important that your clients know that there is an alternative way out of this. Money damages are all the plaintiff can ask for. Nobody can restore, we say this when people lose loved ones or that they have some meaningful part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. Knowing that, there's a huge opportunity to try to resolve a case like this. And I would urge the parties to have very frank discussions with their lawyers about that and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell them all about things like the time it takes to get to litigation, what we have the burden of proof. Yes, it's easier with a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have 2 ongoing, as far as I understand, the 2 businesses in Canton are ongoing, and they have their business decisions they have to make. Ultimately, they're defendants in this case. They have to understand the risk of going forward in a trial versus resolution. Of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment and what that will mean in terms of ability to put this matter behind and going forward. It's going to be very complex. So you can resolve that by looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you could do as soon as this spring, if you want to. Okay. Anything else we need to address this afternoon?
not from the defendant, Your Honor.
Okay, great. I'll issue a decision on the motion to dismiss. Tracking order stays in place as it is now, but here's my concern, folks. With this motion that the defense team is talking about putting together, I think that needs to be looked at sooner rather than later. It's a big deal, right?
Yes, Your Honor.
Okay. Why don't we get a status date? When do you want to, and we can do it by Zoom, folks, if it's just as easy. My order was to have everybody here so that you all get a chance to meet. I want people to be understanding that this is a civil matter, and I want you to be, at least to some extent, trying to be civil about how to resolve your issues. I would have liked to see, for instance, this motion that was brought about in open court should have really been discussed ahead of time so you have a better position on it, but I don't want to waste your time. You want to do next hearing by Zoom? You want to do it in person? You tell me. Plaintiff?
We're agnostic, Your Honor. I'll do whatever.
We're agnostic? Is that what you said?
Yeah, as it relates to that, we'll come in person or we'll do it via Zoom.
Defense?
Your Honor, we prefer to be in person.
Okay.
Either way, Your Honor.
Okay. All right, we'll do it in person. Fine, we'll do it down here at Plymouth. I will be moving into the Brockton court next month, but this is especially assigned, at least for now, so I'll come back down here. That's not a problem. Mr. Clerk, do you want to suggest a date for us?
Sure.
Mr. Clerk. Mr. Clerk.
I see what you did there. Now we all have to stay on for 15 minutes to ring in the new birthday for Mary B.
We can ring it in early.
No, we can't.
You're like, fuck it.
I know.
Get it over with. I gotta go to sleep.
Already asleep. But
I'm
Dean and
gonna
I
hang
have
in
not
here
done
for
it
Mary
yet.
B's birthday, Danny.
Oh,
Okay, I'm not telling you gotta leave. I'm just telling her that you're probably gonna leave, so she's not.
She's telling me I
disappointed in
should
you
leave
too.
as a responsible
Dean's gonna
parent,
fall
but
asleep. On the
I'm gonna
melatonin.
hang out 15 more minutes.
Janine's on that toning.
I'm gonna what? I didn't hear you, brother.
She's on that
Oh,
tonin
you're on
with
that toning.
extra magnesium and something else I didn't even know what she was
They
talking
call
about.
it brain,
Yes, I
brain
took
drain.
my
Is it
sleep
brain drain?
free. It's melatonin with ashwagandha.
Oh, that's green drink. That's green drink, baby. Green drink. You want that green drink?
It relaxes you, so yeah.
And meth cleans your sinuses, but
I didn't know, Danny.
it does.
Here's my
It's like
needle
a super powered Sudafed. It's just all
It
all it-
also cleans out your toxins through your pores and leaves evidence of it.
I didn't say it was good. I just said
Yeah,
if you had a stuffy nose and you couldn't find some Sudafed,
Duly know it. Duly use my meth for that next time.
yeah. If you can't find Sudafed, but you can
with a,
find that.
with a Vicks
I
vapor
can't
rub.
find
If
that
the Vicks vapor rub doesn't work,
on
you're
these streets in Connecticut. Actually, probably could find some. Right.
Yeah,
Wait,
Bridgeport.
that brings up an interesting point. You're bringing up Vicks Vapor Rub. So do people in the north put Vicks on the bottom of their feet as well?
What? Okay, you gotta
I've never done that.
me. I need it.
Don't make that
Yeah,
a
for
subject.
what?
Down here in the
Well-
south, we boil Vicks and drink it, but people also put it on the bottom of their
Damn,
feet,
Lauren.
put socks on, and sleep in it, and it
We
will.
do not. I told y'all them Louisiana people were weird. She's like, you ever put
No,
banana
I'm
pudding on your
serious.
feet when you're sick? Like, what? What are you
Put
talking about?
Vicks on the bottom of your feet, put socks on, and sleep, and you will wake up completely free of congestion the next morning.
My
Oh,
I
grandma
have heard that, yeah.
was a
All
real
right.
person.
I've never heard of somebody drinking it though. Like
Yeah,
that
that's
is
kind of like an old timey thing. Like grandparents and great grandparents would boil it and drink it.
Never heard that.
Did your grandparents boil it and drink it, Laleen?
They made me, yes.
Oh God.
And you were okay. You boiled the
Then you're
Vicks
still
vapor
alive.
rub.
you're
Oh,
okay.
Yes.
cool.
They would put
Gen
it in tea and
Vicks is
stuff like
anything.
that, and I would drink Vicks and I would be fine.
That's horrible. That's not a southern. That's not a southern thing. That's not a southern thing.
Yeah, on the West Coast, we used to just smoke it. You know, we'd mix it in with our
I
meth,
don't doubt
Nice.
that
and
one
we would
bit.
just fucking smoke it.
Dip it
Yeah.
in formaldehyde and then write in that Vicks vapor rub to make it a.
I'm
make
telling
it
y'all
a-
though, if y'all have never tried putting Vicks on the bottom of your feet and put socks on when you go to bed, it is like a miracle cure.
No,
And
I have
also
heard
putting-
that. I have heard
Putting
that.
bars of soap in your bed up under your sheets next to your legs will help with leg cramps at night too.
Oh my God. I think you just saved my life.
Bananas.
I went years
Yes.
sleeping
Bars
with
of
bars
soap?
of soap in my
Soap?
bed. Yes.
So like you'll kick them around at night?
Yep. I would have 3 or 4 and they would fall and get down under the fitted sheets. I'd just throw another one in there.
All right, good to know. I'm gonna try that.
Mm-hmm.
Yeah, my grandmother was kind of paranoid. She was funny about it. She used to tell me when I was a kid that you could just take a potato peel and rub that potato peel on anything. Yeah, if you had a scratch or if you were itching. I got poison ivy when I was a kid a lot, and I'm super allergic to it. She used to tell me that, and it would just make it spread.
So don't do that.
I
You know
haven't
what
heard
sweet,
the
you know what a
potato
sweet
peel
gum
thing
tree is?
before.
You've seen a sweet gum tree. If you've ever lived around one, you know how horrible they are with their little gum balls.
Mm-hmm.
My grandparents told me that's where gum came from. Yeah, out in the backyard eating pecans and chewing up damn gumballs. Like, I just don't understand why the bubble gum tastes so much better than this.
Bubble gum. Yeah.
I'm not getting any gum out of this.
Because they
I go
add
for the good
sugar and
part.
preservatives.
That's why I don't get sick either. I haven't been
Mm.
sick in so long.
That
And
has a lot to do with it. Our immune systems in the South, like our generation, seriously, like we're immune to a lot.
Drinking the
Yeah.
Vicks.
Just there's more weird shit to put in your mouth when you're a kid in the South,
Yeah.
in the woods,
Me
than it is on the streets of New York.
Yeah.
Radioactive.
You're walking around down here chewing up sticks, got a piece of grass in your mouth or some shit walking around.
It's a very common thing.
That was before you started smoking. After you started smoking, then you just
Yeah,
been
then it's just cigarettes.
yeah, but before then it's just a long blade of grass. You know.
What
Which
do
actually
cigarettes
tastes
cost
pretty good.
in the chat? Seriously.
What do we
Because I
pay?
know they're more expensive up north than they are here.
Oh, they're way more expensive up north.
MJ and
$10 a pack if you buy
and I
one.
bought a pack of Marlboro
Lights.
and they were $15, and they
Yeah,
were
if you want the good ones, they're up there.
every penny. So if you the
My
Marlboro,
Marlboro Ultralights were $11 today. I think that's the most I've paid for them here.
oh my God, if you dip them in the Vicks Vapor Rub, are they like Newports?
They're definitely like a menthol for
You
sure.
put 'em in your-
You can't buy
in your
Newports
box,
in
and you gotta
Massachusetts.
sleep
Will
with
they
them for at
cure
least
the
one
cough
night
that
while they
cigarettes are
marinate.
causing?
What?
You rub your feet down with Vicks, then you stick the cigarettes to it, and you put a sock on. Next day, you got a pack of menthols.
Well, people in Massachusetts need that trick because you can't get menthol cigarettes here.
Put it in a
They're
crock.
only 10 times worse for you than
Crock
regular.
pot will do everything. Works magic. Put the Vicks Vapor Rub and the cigarettes in the crock pot overnight.
I
You
could
were like
probably
a
make a lot
menthol
of
guy,
money
Dean.
doing that.
Could
Have
you?
like a
Let's
black
invent.
market Newport store.
People will buy anything. They'll buy it. Let's just creative marketing. That's when we do our grilled cheese stands and our T-shirt stands, and then MJ's gonna make the stickers, and we'll make the menthol cigarettes.
Yeah, we'll make some menthol.
Good business.
Come to our fair. It's the only place in Massachusetts you can get menthol cigarettes.
Dean, what are you watching?
What do they have? What do you have against menthol cigarettes, though?
Watching, like,
So
furry
it's
videos
considered
and-
flavored. And you can't, so we can't buy flavored vapes here either. I have to leave the state.
The
to get
rats have gotten Dean a little worked up. Now he's watching.
No, I was scrolling through the comments, and then I was gonna go to your YouTube stream. Now I'm looking at the new cat. But I was gonna go to your YouTube stream, and I was gonna try to gift memberships again. But now that you called me out, Danny, I just don't think I'm gonna do it, man. So.
Oh God. Yeah. It'll
Also,
probably-
I'm trying to keep track of the pizza I ordered. So I'm doing kind of a lot, Danny.
Did you get stuffed crusty?
No, but I got pan. I like the pan.
Yeah.
Yes, pan. can with everything on it.
Danny, why didn't Johnny's make it where y'all are?
I have no idea because it was in a really good spot.
Johnny's is extremely popular here. Johnny's Pizza. The guy that started it was from my hometown, and we actually have a Johnny's in an old refurbished train depot. So you walk in and it's like the train station, and you can actually, there's 3 train cars out back that you can have your parties on and stuff. It's pretty cool.
Rubicon says no flavored vapes in Montana.
No,
Only Marlboro Reds.
in California too, there you can't get them. Because I
No.
went there thinking that I could get
Our
them. and not-
vapes get outlawed like once a month, and then you have to find the right store who's still bringing them in from other states. But we still have our flavored vapes. But our menthols, I've heard, are about to be outlawed here.
Appreciate it, man. Hopefully it works this time. But it doesn't look like it's working. Hope it's
Yeah.
not. It better give you your money back for those. It may be working, it's just not giving it to anybody in this damn live stream.
But it
Yeah,
would be
usually
showing
it
you.
still lists them though.
Yeah, you're right. It does do that. What's up, Donovan? Donovan, welcome to the Super Chats version of the Rat House.
We are official.
Yeah.
Rocket.
We've already met
Oh my
two.
God, it's so
goals.
weird to see. Oh, you gifted memberships, Dean.
No.
Gingy,
what?
I know. Diane G gifted 5, then Dean gifted, now he's gifted again, but they're all like not being distributed. They're just showing up.
I got a feeling that these memberships are going to cost me Venmo money. It's real.
Wow.
Refunding.
No, YouTube
Terry
will do
said to
that.
give it time that it should kick in
Yeah.
eventually.
YouTube.
Yeah,
will do
probably
that.
next stream.
Which is just more motivation for people to come back.
Well, that would be first and only motivation they have to come back. Hey, we can go back to that crap show and spend money now. It's crazy what you can do on there. Damn it. This glare went off. My iPad went off.
4 minutes till Mary B's older.
Oh my.
Yay.
Countdown.
What time were you born?
7:10 a.m.
Oh my
Well,
God.
we're not
it's not
staying
your
on that
birthday,
long.
man.
It counts as the day.
7:10
It's your
a.m.
fucking birthday. We've been sitting here waiting this whole time for 2 hours.
Yeah, right. We just let's fall asleep on.
Now we find out we got to sit here for 7 more hours.
There's
Damn,
Pinky
this is gonna be-
Promises.
hope you got a lot of pizza.
Hey, Pinky Promise.
Hey, Pinky.
Pinky. Oh my God, you made it.
My friend, love you. Mary, where were you in Massachusetts? In Boston?
Right here in Worcester.
Worcester. Yep, in Worcester. Okay, now I can do your chart. Wait, so
I thought it was Worcester.
Worcester.
Well, if I'm saying it quick, I'll say like Worcester, but Worcester is like I pronounce my R's more than others, unless I'm mad.
Because you say it so quickly. We had this conversation with Sweet.
I thought no one in
That's why I
Massachusetts
say
could say
convoluted.
W's. Like everyone that I've heard in Karen's trial says R instead of W.
Yeah, that's another like talking fast thing. But
yeah, Laura.
I don't have an accent at all.
They add R's where there are none, like garage.
Yeah, like
Oh,
idea.
they do that too, but law is lur, like lar.
Law.
Law enforcement.
Welcome to the lar.
I think it's when it's followed by another word that starts with a vowel.
Yes.
Lar and order.
That
Welcome
too.
to lar and order.
Like my mother used to say polar shirt, so I used to call it polar shirt, and sometimes I still do, but it's a polo. Yeah, I mean it's one of those things.
It's just
yeah.
it's just
what
a
our
Mars
ear
movie.
picks up, right? So-
Gingy's asking, are the memberships showing up in your bank account, Danny?
Oh, you have to build up $100 before you can
Before
get
any deposits are made?
Well, they're not. They don't Shit, it takes like 30 days to get it. They only pay out 1 day a month.
Oh, okay.
So it'll be next month before I get paid. If there's $100.
I'm sure
Once you
there'll be
make it to
$100,
$100,
but I feel confident the memberships will show up pretty soon.
well, once you make it to $100, then it prompts you to fill out the
1983
tax
toy.
forms and stuff.
We're
gonna
on
be
the minute
420.
countdown.
Minute. We're within a
Danny,
minute.
you need to find a birthday song that's not copyrighted to play because I can't sing.
Mm-mm.
You can just say it. You can rap.
I don't think I can
I
find
can't
one.
You
sing
can
or
just
rap.
say it. You know what? Actually, why don't you go ahead and rap it?
I would like you to write me a poem.
Put the pressure
Oh,
on me.
man.
Dean's gonna write Mary B a birthday poem.
Oh, he already wrote her one
Yeah,
earlier
haiku.
today.
Dean,
I'm not. No.
There's one on the side
you're
of the
bad.
pizza box.
You're great with words.
I mean, 83 does rhyme with Mary B, so it shouldn't be too hard for someone who's creative. Come on.
You were born in 83?
1983.
You're a damn millennial.
All right, it's birthday time in Massachusetts. Happy
Yay!
birthday, Mary B.
Birthday.
Yeah.
Happy birthday.
Happy
birthday.
birthday
To everyone.
to you. Happy birthday to you.
We
Come on,
so
sing
need
it.
Petty
Happy
right now.
birthday, our
Dear Mary B, happy birthday to you.
Lolene, you promised us you weren't going to sing.
I didn't promise. I just said I can't.
You promised. That felt like a
Didn't
promise.
promise. Said I can't.
We love you, Mary. Happy birthday.
Thank
Yes,
you
happy
guys.
birthday.
Thank you, chat. Thank you, Laura. Thank you, MJ, Misty, Rubicon, Angel, Gingy, Miss Jessica.
Our first official, no, she's technically a Virgo. Our first Libra birthday season birthday. Kicking it
Yep.
off.
I'm a Verbra.
Verbra. Yes.
Verbra, but also a Libra rising. Oh, thanks, Mom.
MJ's other mom is
A
here.
Zebra Rising. What is that?
I'm gonna
A
check
Zebra Rising.
that. Oh, is Mama Lisa here? Lisa, beautiful Lisa, we love you.
That's a good idea. I will wear red lipstick today.
Yes.
Well, what is a Zebra Rising?
Libra.
Libra rising.
Zebra's not
Pronunciation.
an astrological sign, Danny.
It's not a zebra.
Not a zebra. It's a Libra, the scales.
Yeah, you should know
Or
this
excuse
stuff.
the year of the horse.
Oh, you're a cusp, so it's true. Now you have to get the other tattoo though to be complete.
Yeah, right. On my other toe. That hurt a lot.
I know. I always wanted to get that. I wanted to get
Actually, I think the Libra tattoo is a butthole tattoo.
something that had to do with my combination,
I'd get that tattoo.
my chart combination, the big four. The rising,
brought
the
it
sun, the moon, the Mercury, and the Mars. Wait, that's 5. So that's your recipe. That's
I
who
have Virgo and Mercury and Leo Mars.
Oh,
But I also have a Sagittarius stellium.
I don't know. You know, that's Toy's department.
So a stellium is when you have more than three or more planets in the same sign that aren't like your sun or your moon.
Oh, okay.
So I have Neptune, Uranus, and Jupiter.
Uranus.
I knew Dean was going to laugh.
I knew it was a butthole tattoo.
I don't consider those to be very important because I feel like they're more generational. The big ones. All right, so these are the big ones, and we have to start doing chats. I'm tired. So the big ones are the rising, the sun, the moon, the Venus, the Mars, and the Mercury. Those are the big ones. If you know those, you know who you are. Like when I know those about people, I know who I'm dealing with. It makes like super easy. I know you're trying to know how to deal with them.
I'm very confused by my moon.
What's your moon?
I'm an Aries moon.
Oh.
And that's weird to me. I don't think I'm like that.
Hmm.
Like maybe I am, but I don't know. Maybe I just don't.
I could see it. I could see that.
Yeah, to be honest,
But you-
it makes a
you're
lot of sense now
That's a
in
deal.
hindsight.
You don't even know.
In hindsight, it makes a lot of
I
sense.
honestly
doesn't
don't see
know
the
what he's
whole
saying.
like astrological stuff being the same for me and Mary B because I'm an extreme people person. I like crowds, and she's the exact opposite of me. For us to be 6 days apart,
Well, I always
You have a completely different
did. It's
sign
like a learned
chart.
behavior that I don't like people.
It's a
you
what?
learned it.
It's it's a learned behavior that I don't like people because I used like when I drank especially, I went out a lot. I love to be around people. I love to be social. But I was like always I'd go out and I'd have to drink like in order to socialize, like I'd get there, I'd be like, all right, I gotta down one drink real quick and then I can do it.
Maybe you
Now
just
I just
have
go up and I'm like,
anxiety.
I don't think
Laura J.
No, I actually I agree with you, Mary B. That's kind of how I am, right? Like I used to be extremely social, and now I'm just like, just leave me the fuck alone.
Yeah,
Like I don't want to talk.
Like I used to date and stuff. Ugh, that was terrible.
See, we're 6 days apart. I just feel like we're complete opposites. That's just
Still
weird to me.
do, don't you?
What?
Date in the broad term.
Date?
Yeah.
No, I don't date.
No. Oh,
Don't you date? I could have sworn you talk about dating.
Oh, that's not dating.
That's hooking up.
Not dating. Like I'm
There's
I'm
no
getting a
meal
free dinner,
involved.
but it's usually brought to me.
Okay.
Well, never mind then. There is a meal involved. So
Yeah.
it is a date.
Yeah.
Yes.
I get
Well, you just don't like long-term date.
The first half was a
right. I
date.
don't date with a future plan.
Yeah, that's still dating.
Well, not yet.
That's still dating.
When you have a suitor that is worthy of your hand, you will date
That's what we're calling it. Your hand.
your hand.
Okay.
You forgot
I feel
the
like
job.
that term's more acceptable for
I
a
You
forgot.
forgot the
guy,
word
but
job.
Well, now that I'm
Toy-
like a big shot chief of staff of a softball organization, there's a
Mary
lot of
B, where were you born?
Toy
What
has
city
tons
did
of questions for
Well,
Mary
Yeah.
B to get
that's
this
what
reading
I'm
right. So Mary B needs to focus on Toy's questions in the chat to get the
Yes,
reading
Worcester,
right.
Massachusetts. That's
Toy's
correct.
going to work. She's beating me, but she's go do it, Toy. Do it.
You saw me on Tinder, Steve. It might still be there.
That was the whole thing. I'll tell
Mary
you
B
sell
on Tinder for sure.
condoms and your sex toy.
That's
just-
like me in
uh,
2018.
She's not big time. She's just living.
L-I-V-I.
Um,
Say
7
nothing wrong with that. The Dazed and Confused reference.
Yep.
7:40 a.m. I think Toy is
7:10 a.m.
7:10.
okay. So I
7:10.
think Toy is running your chart now.
Yeah.
This is
Toy at 710 and Worcester Hospital.
I'm excited. I want to know.
Yeah,
I have a feeling you don't have any water though. It sounds like you have fire.
I don't.
no, her water broke.
You need
I was
I'm
going to
mostly
say the
water-
same
I'm
thing,
mostly
Danny.
air and
Like
fire.
the water broke before 710.
Yeah.
No,
Water broke.
I was a planned C-section. I was actually supposed to be born on the 26th because that's my dad's birthday, but the doctor that was delivering me was going on vacation, and they
Oh my
wanted me to
So
do
it's
it.
just like, hold on. Just don't
You're
worry
a birth
about
by
that.
convenience.
Due on the 27th.
Yes. And
then
it was on a Friday.
vacation, and then I was born on the 23rd. Yeah, but I wasn't a C-section. My mother said, I went to sleep and I woke up and you were born. And then I was in an incubator because I was like 4 pounds. And they christened me. They thought I was going to die. But this is your day. This is your day. We'll do this in June for me. But that's
Yeah, no, I was just the
Same
third
thing.
child that got forgotten about.
We both would have been different signs. But
Right.
we're cusps.
Yeah.
Well, no, you're the same sign. Wait, let me think. It's the
No,
ashwagandha.
'cause I'm a Virgo.
You're a Virgo because Virgo was
I did.
early that
He's on camera. He's
He's
not
just
eating his
eating.
pizza yet.
No, I had a couple slices. I turned off my camera when we were all saying Merry
When it was
Christmas to
B's
Mary
happy
B.
birthday time, you ate.
I was texting
Merry Christmas,
though.
Mary B.
Is it any good?
It was just Pizza Hut. It was okay.
I
Pizza.
love
When you
I
don't
love
have food,
Pizza
Pizza Hut is
Hut.
good.
Pizza Hut is awesome.
I mean,
should-
it's not like phenomenal, but it's definitely good enough for me to eat. I'm not
Yeah, he's
complaining.
full
No,
now,
I
and
think
that's what
you're right.
matters. He's
And it's
completely
never as
full.
good when you
It's a
get it
little high.
delivered. It's always better when you're there in person.
Is that true?
I'm
It
not
was
Yeah.
sure
always
if that's
better
true.
when my mom used to take
It's
us
not
there
true.
when we had a half day, and we do the
When you get
buffet.
it hot and fresh sitting in the restaurant, it's always better than having it delivered.
Yeah,
Can
with
you
the
get it
cheese.
hot? Lowline 2025.
I can get it hot, Danny, 2025. It's still not as good as Janine's yesterday.
And fresh.
Dude,
If
that
they don't
salad
come,
bar
I
though,
don't get
Steve.
paid.
Yeah.
What? Wait, what did I say? I didn't
Steve
screenshot.
called it the Slad Bar. I'm not sure if I like that. The
Yesterday or
salad
last
bar, I'm
night,
cool with.
That creamy Italian though.
I said something about coming in
last
2020.
night you said if they don't come, I don't get paid.
Yeah. If they don't come, I don't get paid.
Yeah, right. Yeah. And that
That's what she
happens
said.
to me on Saturday. She didn't come, so I didn't get paid.
I really think you need to set up a cancellation policy though. Like if they cancel within an hour, that's full price. Within 3 hours, half price. They need to have a card on file. You need some reassurance and a backup plan there, girl.
Not well, you know why they don't do that? Because at a spa, they're like, well, fuck you, massage therapist, because if we charge her, she's not going to come back for facials, massages, injections.
Well, then you should be paid an hourly rate by the massage parlor or spa, whatever, for showing up.
I agree. I wish it were different, but you know what? They allow me to. So I punched in. I was like, "Fuck it," and I did laundry for a couple hours. It wasn't the same. It pissed me off, but at least I made something. So, oh well. But thank you. I appreciate the support.
To me, it's only fair.
It's true. It's not fair. It sucks. So one time there was I woke up, I thought an hour's worth of traffic. I got there, I set my room up, and then the receptionist came in and she said, oh, so-and-so isn't coming because she's 11 weeks pregnant and she's paranoid. And I said, well, didn't she know she was 11 weeks pregnant last night? Why the fuck did I have to? I didn't say fuck, but I was like, what? I was so pissed off.
And y'all have accommodations for pregnant people. I mean, you could have set up a pregnancy table.
Yeah, I understand though. I wouldn't have done it. Like in the first trimester, I would have been really paranoid. But you know, but she knew the night before, and then I had to wake up early. I had to fight the traffic.
I think they assume that you're there when they open, no matter what your schedule is.
They should. They should charge. There should be like a basic charge, but they won't because they don't want to lose the business. So it is what it is. Sucks, but
well, that should be relayed to them when they're scheduling. Then that you're not a hourly employee. You're coming in specifically for them, so there is a cancellation fee.
Yeah, I agree.
You don't have to speak up to these people, girl. Stand your ground.
I know, but they're not gonna. I mean,
address.
They did right. Yeah, bitch, I want my money.
Go trash their lawn.
Yeah, bleach will on your lawn, motherfucker. I know, but they do that to all the therapists, and then I was so mad that one time I was like, oh, I was so mad, and I went and I was kind of like, you know, not complaining, but I was like, oh, you know, so and so, you know, didn't come in, and they were like, yeah, it's annoying, but
no, it's not annoying. You gotta,
we just
come
live
on, girl, get strong. It's not annoying. I paid for the gas to get here. It's my time to be here. They're gonna pay me. You're gonna pay me. Somebody's got to pay me.
Somebody's got to pay. Yeah, but they don't.
Seems like she's got that kind of attitude anyway. She would already be doing that. She don't sound like she takes a lot of shit.
Who's that?
You.
Oh, well, I mean, no, normally not, but that's my
She doesn't want to walk on anyone's toes, and she's trying to keep the peace. But sometimes you got to just stand up for yourself.
Well, that's the policy, though. You know, like they do that to everyone. So, like, if nobody shows up for the facial, the estheticians don't get paid either. So,
Damn, that sucks.
Well, that's
It's
what I'm
true,
saying.
yeah.
That's not a well-run establishment. Then these things need to be put in place by management.
I
At
think
least
it's just,
$5.
I think
One gallon of gas.
don't want to alienate their business. You know, like their
But if you put it out into the universe that you can walk all over our
What is the
employees,
main thing they do? Is it a hotel? Is it a?
No, it's just a spa. It's just like a day spa.
Okay.
It's a spa. They do injections, they do facials, and they do massages. It's just
but
a
I
regular
bet you
spa.
there's a lot less people missing their injections than they are missing their facials and the massages. They're gonna
Right.
be there for them injections.
Yeah, yeah, that's true. That's true. They're very busy. The injectors are very busy. And the estheticians, you know what I realized being in spa since because I had never done spa, that people will prioritize their looks and not the way that they feel. They'll walk around,
Yeah.
but but they'll come for their facial, but they'll miss their massage because it matters more how they look. And it's just the reality of it. Yeah.
Yeah, that should not be a surprise once you get our age. We know that.
Yeah.
We will sacrifice how we feel
Ginger,
for how
did
we
it
look.
tell you
on it.
that?
I
Did
don't
it give
care how
you
I
a-
look.
It tell
Aw,
you you got like a
you're
minute
beautiful.
timeout or something? Ginger got timed out by the YouTube.
I've seen every comment she's put in here.
Yeah, I haven't seen.
I hadn't seen anything, but she said she was
Yeah.
talking about the sea.
Y'all are just so wrong to do that to Gingy.
Yeah, that's messed up.
Uh-oh, what happens with
It was
Gingy?
probably Dean.
No, I didn't. I didn't time her out.
Dean, come on.
He wouldn't lie about it because he'd already
Yeah.
be laughing.
You
Yeah,
don't
no,
know.
exactly. If I time somebody out, I'm gonna tell them.
I don't think I do.
Yeah, and don't let it happen again.
No, I don't. I didn't want one.
I mean, it's only what Clerk, Dean, Toy, and Angel who are mods.
Yeah, that sounds about right.
All the best people. Yes,
And
you're right.
MJ.
MJ's
Oh,
a
except
mod?
MJ.
Benji
All the
should
best
be a
people
mod.
except MJ.
He's got boss energy for sure.
If MJ's a mod, she might be in trouble then. I don't know.
MJ does like to fuck with people and then lie about it.
That's
I say,
so
I say
MJ.
Disney and Prince Lover should be mods too. You should all be mods.
Everybody blaming on everybody now.
Everybody but me.
Y'all don't leave Gingy alone. I'm gonna make her a mod. Even though-
MJ's blaming Angel. Angel's blaming MJ.
Gingy
Here
was
we go.
born to be a mod. Got that energy.
She was, wasn't she?
I vote.
I'm
I
gonna
vote.
make everybody a moderator again, but I can't do it. They won't let me.
They won't?
Then
No, the
how does Grande
The people
get
that manage me won't let
all
me.
those wrenches?
Okay. I was like, you
I
making
could.
shit
I
up
could go
now?
crazy. I did that last week. I went crazy and made like 5 of them. Then I had to take them back.
Yeah, stuff
Janine and
started
I
happening.
released our mod obligations because we don't know how to use it anyway. So we're
Yeah,
I
fine.
don't know what to do with
I'm
them.
not a mod
How
either.
to wield that power.
I'm not even a freaking member. I can't even use the damn emojis. Member.
Well, then buy your own membership, Danny.
It won't let me.
Hey, you can make an emoji. You can make the big rat daddy emoji now.
Dean,
Yeah,
do you
well-
have any insight on that?
What?
Why he can't use his own emojis?
No, he's for sure able to use his own emojis.
I'm telling you, I can't. I already done
The
it.
FaceTime and show him how to do it.
I
Dean.
love emojis. Yeah, they're not in here. I'm not a member.
Yeah, but if you're using like the account, like your YouTube account that you're streaming from, you'll be able to use them.
Why the fuck else would I stream if it wasn't from my account?
Well, some people use a different account. Like they'll monitor their account with a different account.
Okay. I'll figure it out though.
Yeah, I agree with MJ for once. Finally, MJ makes a good point, one that's worth repeating. He's just special needs.
Yeah.
Oh my goodness.
Darn. Man,
This cat's being very needy tonight.
love the awkward silence.
Awkward silence.
I think it's
You gotta
about
love
that time, Danny.
that's the part. That's the best part.
I'm starting to question Janine's sleep aids because she's been here for an hour and she's still going strong.
She is asleep right now.
I
That's
feel like I am. I kind of feel like
she's
I am.
just floating,
Yeah, can we go now?
like hanging out with pink elephants.
It does feel like a pseudo high a bit. It's
Yeah,
kind of
must
fun.
be weird.
The closest I have been to high in a long time. This
Oh,
afternoon.
come on. Those 2 cigarettes had you pretty high and out there, dude.
Oh my God, that's
They
the
were
best.
strong,
Nicotine,
strong
the hell of a
cigarettes.
drug.
It'll do it sometimes.
Oh my God, I love it.
Wake up the next day like, damn, I smoked a bunch of cigarettes yesterday. I can't breathe.
Hmm.
Great. It was great. It was worth it. And then Picky, so when we woke up, I was like, oh, I feel like shit. I have to take like an hour-long shower. I felt so much better. And then Picky's like, hey, what happened to those cigarettes? You still got them? I said, yeah, there's 3 more. Here, you take them. So she went out and she smoked them.
Damn.
Badass. Love her. Anyway, all right, we're going to close this bitch down, brother?
Yeah, I don't see why not.
Why not?
I didn't
We had
even.
our awkward silence. We wished Mary B.
We watched the
well
hearing. We
wished.
finished it.
Yeah.
Watch the
Finished it
whole
before it
thing.
started. That's crazy.
It's been a
Yep.
great
It
day.
helps that I had 700 things to try to learn with my ADHD powers, which I don't really have ADHD, but
Are you
I
sure?
don't know. After some of your streams lately, I'm starting to question that.
I think you might.
Sure.
I can, when you can split screen shows, I can watch like 4 or 5 at the same time.
Yeah.
That's what you call
That's
ADHD.
fair.
Yeah.
Even
that
though
is
you're
definitely-
able to concentrate on more than one, the fact that you need more than one is the point.
Yeah. You're one of
Yeah, I also agree, Danny. You have a problem.
Yeah. You're telling me
It's okay. Know thyself. That's
because
all.
I'm also watching Kevy Kev dance with his glasses on his head.
I'm convinced you're watching something now.
I am watching Kevy Kev dance. He was here hanging out last night.
That was great.
Yeah.
Kevy Kev.
Kevy Kev.
We get celebs.
That's
Yeah,
right.
yeah, he's doing like a cardio workout dance right now. He's working it out.
I just have a fear that Microdots is never going to be able to finish his most recent video if LG continues all of her shenanigans. Like after her filing that motion, then going on X and posting a video, like I feel like she's
Madness.
prolonging our Microdots video.
Madness.
Oh yeah.
Yeah, Kevy Kev was here last night. There was actually like 55, 60 people here the whole time, and then it was about 150 watch hours, and it was like, oh, wait, don't fucking car.
Wah, wah. Sorry, brother.
That one was out of the blue too. I was like, oh, what the fuck is this notification? Because I just got the good notification, and it was like, oh, just to let you know.
Yeah. Also,
You were doing great
don't get too excited.
right up till you weren't.
It's just a hiccup. It's just a
Now we have to go 90 days because I had to go to fucking copyright school today.
That's fun.
I ain't no shit. I had to go to
And
YouTube.
then Kay, I'm sure
Yeah.
Dr. Lapisato will be in the civil trial as well as ARCA. They'll all be in there stating there was no collision.
Can't wait.
It's a whole other batch of lawyers that we get to despise.
Nope, can't wait. So excited.
Why not?
I'm surprised they're already like talking about setting a date for next spring because usually civil stuff draws on for years.
Yeah, that costs a
Okay.
lot.
Oh yeah.
I mean, it's already September, so the amount of depositions that are going to have to be taken between now and then to get ready for a trial in spring is not very realistic, especially
doesn't
after
matter.
announcing that she's suing all the McAlberts and Higgins and MSP and Canton PD. So I don't see that happening.
Oh, hi, Kitty.
So Dean, why isn't it
Pretty.
using my crazy eyed cheese icon for the membership icon? It's using that damn stock
Hey, I just won more
I don't
money.
know.
Yes.
little S right there.
Oh,
Supposedly-
that's on StreamYard. That's on StreamYard.
Promise.
But in the chat on YouTube, it shows it as the image.
Oh, you bastard. Let me go see. It is crazy eyed cheese.
There he is.
That's what he's been waiting for.
Damn. Good answer, Dean. Because I was worried about that.
Yeah, no problem.
It's working. Maybe Kev getting after it, son. Glare is up in the chat.
All right, well, let's go see them.
They're all. I'm not going in there. I'm going to bed.
Yep. Yeah, Mary B, yesterday, your birthday beauty.
Melatonin.
You have the best day ever.
Thank you so much.
Solid 8.
Yeah, we're going to birthday stream later.
All right. Yeah, pregame.
Yep.
Hopefully I can get home in time.
Yeah, we're gonna play beer pong tonight.
Beer
Yeah.
pong.
Yes.
And eat cake.
How are you going to play beer pong when you don't drink?
It's a good question.
You can play Dr. Pepper pong.
Yeah.
Mm-hmm.
Love you
Or
guys.
beer
Oh,
pong.
So much.
Okay, well, my
Let's
computer
do
might shut off in a minute because Cat is eating at my wires. So,
Hate when that happens.
all right, guys.
All right.
All right.
Dean.
Night.
Say goodbye to everybody.
Good
Everybody.
night.
Good night,
Thank you.
Hannah. Good
Love
night,
you
Kat.
all.
Congratulations, Danny.
Congratulations,
Danny.
brother.
Appreciate it.
Woohoo!
We'll get all this stuff smoothed out. It'll be a good time.
Yep.
Have a good one.
Chat rats, y'all ready? Light it up. Light it up. It's that time. Let's roll.
Got the crew on the dial and we setting out east. Rat daddy at the wheel on the trail for the beast. Toy got receipts and a pocket full of names, and we busting out truce like we blowing out flames.
Eastbound and down, chat rats rolling heavy. Truth on our tailgate, justice riding steady. Mic in our hand and the signs all red. Ain't no lies slipping past what the chat rat said.
Clerks got the playlist, angels taking charge. Law leans on the mic and her notes hit hard. Mary B's lifted, but she's sharper than attack. Dean's dropping questions while he's rolling in his Cadillac.
Break a rap mama here, got eyeballs on that shady scene. Y'all ready? Light it up, rats. 10, 4, 20. Northbound and bold, truth in the backseat. Chat rats got that heat. Can't be beat from the chat rats lounge to the courthouse gate. We ride for the truth and we show up to see that fate.